Hello everyone. Good morning. Good morning. Please, can we all hear me?
Yeah, I can hear you, but you're a bit faint.
Okay, is it better now?
Yes, it is. Thank you very much. Good
All right.
morning.
Thank you, Mr. Good morning, Mr. Abdulbaki. Thank you very much for that. Good morning, everyone. My name is Dennis Williams, and I'll be your moderator for today. Thank you so much to everyone for joining in for the class. We are happy to have you all in session today. Please, I would like to kindly remind all the mentees, or I would kindly like to ask from all the mentees that are here on call to kindly please remind the other mentees that are yet to join in that class has started. You can post in your subgroup that class has officially started so that we can move on with the session. And I trust we'll be having a very wonderful and very intriguing and also interactive session today. Please, I would like to also ask from our mentees to kindly try to make the session as engaging as possible. You can always respond to the things the mentors are saying. You can use your emojis, you can turn on your videos so that we know that we are having a session that is interactive and engaging. So moving on, right? We're in week 5, like I said, and we've gone through week 1, and now we're in week 5. We are fastly coming to the end of this mentorship and internship program, and our topic for today is enhancing energy contracts. We've talked about the fossil fuel industry. We've talked about power industry. We've talked about renewable energy. We've talked about energy crisis, and today we are talking about enhancing energy contracts. So moving on, like we started announcing last week, we are still like we started announcing last week. Sorry, please, if you have your mic unmuted, please can you kindly mute? Okay. So like I was saying, we started announcing last week about the JIIPCC Academy free legal clinic for creatives, entertainers, athletes, innovators, and startups, where they will get a 20 minutes consultation slot with our professionals, and also they can get to submit their contracts for reviews. Please, I would like to kindly request that you spread the word about what we are doing, right? So that we can have people engage us on that level, and then we can offer this service that we are doing for free, right? That's the registration link there on the flyer. You can reach out to me for more information as regarding this particular opportunity. So moving on to introduce our mentors for today. Firstly, we'll be having he's not yet here on call, but we're expecting to have Mr. Ayobami Dafe Iola, sorry. Mr. Ayobami has been with us in few of our sessions, and it has been wonderful learning from him all through the way. He has been precise, documenting and using his presentations to he has been very instructive in his precision towards addressing the subject matters he has been given the opportunity to speak on, and we are always happy to have him in class. The next mentor we're expecting in today's class is Mr. Uboho Inyang. Mr. Uboho Inyang, I think he's already here with us. Thank you so much, sir, for joining us. You have also been here with us in a few sessions. We are happy to have you again in class. Thank you for Thank you for everything that you do for us. We look forward to learning from you in today's session, and we hope to have a very, very educative session from your end. So, last but not least, we have Miss Egongong Ogbo. She's not yet also here, but I'm sure she'll be joining us shortly. Miss Egongong has well over a decade of experience in legal practice as a legal practitioner, holds a bachelor's of law degree from the Benson Idahosa University, and was called to the Nigerian bar in 2011 after being awarded a first-class honors degree by the Council of Legal Education Nigerian Law School. Egongon holds a master's of intellectual property commercial law distinction from the University of Sussex, United Kingdom, and a master of business administration from Warwick Business School, University of Warwick, United Kingdom. Kingdoms, Egongon gained experience in dispute resolution, corporate and commercial law, mergers and acquisition, debt recovery, and energy law, where while she served as an associate in the law firm of Paul Usoro and Co. and Alex legal practitioner. Egongon joined the legal team of Green Energy in January 2016 as an in-house legal counsel, and thereafter rose to the position of manager legal, where she oversees the legal team, advising the company on a myriad of of legal issues pertaining to the operations and management of oil and gas assets, oil and gas commercial transactions, projects and corporate finance and compliance issues. As company secretary, Egongon advises the board of Green Energy on corporate governance matters to ensure effective board practice in line with the company's corporate values and best practices aligns with the company's corporate value and best practices sorry and best practices in line with company's corporate value and best practices. Egonhong is an active member of the Association of International Petroleum Negotiators. Thank you so much. Those are our three mentors for today, and we hope that as we delve into today's class and as we look at today's topic, would have a very, very wonderful interaction. Moving on over to our mentors, Mr. Mr. Ayobami has asked for 15 minutes, and so I think we'll be starting over with Mr. Uboho. Mr. Uboho, over to you, sir. The floor is yours for your presentation on today's topic.
Okay, thanks, Dennis. Thanks, everyone. Good morning once again.
Good
Please,
morning, sir.
I sent my slides. Can you please project?
I'm pulling that up now. Thank
Okay.
you.
All right.
Okay, sorry, just a minute.
That's okay.
Okay. Yes, sir, your slides are up.
Okay, perfect. Morning once again, and thank you for having me. So yeah, we'll be talking about, as the moderator has already noted, enhancing energy contracts, compliance, and dispute resolution strategies. Basically, we're looking at regulatory compliance strategies, and obviously, we also talk about the different dispute resolution mechanisms that apply to energy contracts. So first, next slide, please. Our outline, as I've already stated, we look at some of the notable contracts in the energy sector. We'll look at the regulatory compliance strategies and dispute resolution strategies. So we go to the next slide. First, the major industry standard contracts. There is the production sharing contract, which we call the PSC. Or profit oil, it makes room for profit oil sharing. We have PSCs in Nigeria a lot, where the international oil companies are being contracted by government, who come in, are given the opportunity to invest and carry out exploration on oil and gas assets. In return for that, what happens is that instead of the government spending any money, because I mean, the PSC came is a brilliant way where governments, instead of spending money, they bring in investors, for instance, IOCs, to spend their money, develop an asset. When the asset starts producing, the government will now say, okay, we'll now bring out the oil that is produced. Let's say you are bringing a barrel of oil. There is a pre-arranged sharing template. First things first, they are going to deduct the tax costs, the royalties, all the expenses incurred in the production of that barrel of oil. So if a barrel of oil is $100, let's say they have deducted the cost involved in producing that barrel of oil, maybe about $40. So $60 will now be left as profits. In doing that, that profit oil, they have deducted the oil that equates or is proportional to $40, which is for all the costs and expenses. The part of the production that represents the profit, which is, let's say, $60, will now be shared between the government and the IOC or the PSC contractor. So that is what a production sharing contract typically signals. Concession contracts. Concession contracts are quite different from a production sharing contract in the sense that in a concession contract, the rights, not the ownership rights, but the rights and interest in that asset is allocated to an investor. In this sense, the investor or the IOC or oil and gas company, any oil and gas company, is not being given a share of the profit oil. In this case, the concessionaire carries out development of the asset, and when production starts, the concessionaire sells, and what the concessionaire will do in return to government is to pay back the government in terms of taxes, royalties, and all government takings. So that's a concession contract. Then in a concession contract, there's a situation where you say, even under PSC, you can have a situation where instead of having one contractor or instead of having one concessionaire, one entity serving as one concessionaire, as a concessionaire, you could say, company A, I will not have enough money to develop this asset. I'll bring in another partner to join with me in jointly operating this asset. To do that, you enter into what is called a joint operating agreement. That joint operating agreement, just understand it to mean a partnership. Just understand it to mean a partnership agreement, to make it simple. In order to govern the joint operations of the parties that have jointly come together to develop an asset, whether as concession, even PSCs, they can enter into they can carry out operations jointly. They would enter into a joint operating agreement, so to speak, more like a partnership agreement to define their relationship. Like I've stated there, a joint operating agreement. So joint operating agreements are also typical industry standard contracts that you see. These ones are mainly for oil and gas or for the petroleum sector. We have talked of petroleum sharing contract. There is also profit sharing contract. It's almost the same thing as a production sharing contract. Sorry, I kept on saying petroleum sharing contract. I'm sorry, production sharing contract. The first one was production sharing contract. The profit sharing contract is almost the same thing as production sharing contract. However, in this case, the PSC contractor, instead of being given a share of the profit oil, the PSC contractor under a profit sharing contract will take all the oil and sell the profit oil and then generate the revenue and give government in cash a share of the profit. Remember, production sharing, the profit oil is shared, divided between government and the investor or the oil and gas company, not the money. But in a profit sharing contract, the contractor will take the profit oil, sell the profit oil, and then gives government its own share of the profit monetarily, not production. Rig service contracts, RSCs. In this, the difference between a rig service contract and a PSC, for instance, remember, even under the PSC, the contractor is providing services. But in this case, the contractor is not paid a predetermined fee. It's paid by virtue of profit generated per time. But in a rig service contract, you bring in a contractor to say that the government in this case will not also make any expenses on an asset. Title, there's no interest. You bring in the service provider. The service provider will provide the technical services, provide the funding. At the end of the day, what will happen is that there's a predetermined fee in the contract that the government will pay that service provider or service contractor for the services rendered. So the service provider or the service contractor is not entitled to profit share per barrel, is entitled to the fee that has been stated predetermined already under the RSC or the rig service contract. We have already talked about the joint operating agreement. Now, these are all for oil and gas or petroleum transactions. I'm going to jump there a little. Okay, for power sector, electricity, you have typically a power purchase agreement or power purchase agreements, PPAs. You always hear that. Power purchase agreements, as the name signify, that the agreement entered between a supplier or generator of an electricity, let's say GenCo, with an off-taker in the sense, a buyer, purchaser of the generated power or contracted power. The agreement that governs their relationship is a power purchase agreement. You typically always find this if you are practicing in that field. But there are other ancillary contracts that will be part of this arrangement. So in addition to the power purchase agreements, if the GenCo, the generation plant, is a gas-powered plant, you would need to supply gas. The GenCo will need gas as feedstock to fuel the generating plant. In that sense, the GenCo will need to enter into a gas sale purchase agreement with a gas supplier who is operating in the oil and gas industry. So you see, in some cases, you have a relationship or a connection between what is happening in the power sector. You have a myriad of agreements cutting across both the power sector and also the oil and gas sector. So that is where you are talking of the gas sale and purchase agreement. It necessarily must not be with regards to a GenCo. You also have gas sale and purchase agreements between gas suppliers and other users of gas in the oil and gas sector downstream. Even your LNGs, all sorts of, in whatever form, there's always first the purchase of that feedstock gas, which is defined through the gas sale and purchase agreement. In the gas sale and purchase agreement, in the power sector, there was an arrangement, there is an arrangement introduced by government because of the liquidity issues that happened at some point during the privatization of the power sector. The government introduced, part of that, government introduced the Gas Aggregation Company of Nigeria, GACN. So the Gas Aggregation Company of Nigeria, I think we discussed this some time ago about the gas, if I can remember, the domestic gas demand obligation, which was introduced to ensure that there is gas supply within the domestic industry, especially for the for the powering of strategic industries. So government introduced the GSCN as the aggregator of the domestic gas supply based on the domestic gas supply demand obligations. So the GSCN in this case, the kind of gas sale and purchase, if the GSCN is involved as a party to a gas sale and purchase agreement, in addition to that, there will be a part introduced there known as aggregation. So you have a gas sale an aggregation agreement because the GSCN is involved as an aggregator. That is for, like I said, particularly gas sold as part of the fulfillment of a company's domestic gas demand obligation. I think we discussed this some time ago. Let us not diverge from the topic, but generally you have the gas sale and purchase agreement, and then you have the connection agreement. Connection agreements, this is a compound word for different agreements, simply agreements that make room for connection to several transport facilities. Be it in the power sector, you can also have this pipeline connection or tie-in agreement, wherein as a supplier and a purchaser, you have to ensure that that gas that is being purchased right from the gas supplier gets to the purchaser or the off-taker. In that sense, if there must be a transportation facility. If you as an off-taker, you do not have the facility to transport that gas down to your facility, you will need to make use of an existing transportation system or pipeline network. In that sense, you need to enter into a tie-in or transfer or connection agreement with the owner of that gas pipeline. And that is a tie-in agreement or a connection agreement. Same thing in the power sector. If you as a generator, a GenCo, you want to, for instance, sell power to an embedded customer. An embedded customer in this sense, let's say a cluster of industrial customers, big industries who use power, who need a lot of capacity, which they do not need to get from the disco. So they normally sometimes, not even some, they are allowed under the law to transact directly with the GenCos instead of transacting through the discos. In that sense, they have to enter into a transmission use of system agreement with the owner of the transmission network. So that's also a connection agreement of some sort, because at the end of the day, if you are purchasing from the GenCo and you don't want to use the network of a disco, you have to enter into an agreement with the transmission network owner, which is what we call the transmission network use of system agreement. That's also a connection agreement. You can also enter into an agreement to use the distribution facility of a disco. That is what is called the distribution network use of system agreement. All of these are forms of connection agreements. Having said that, we have looked at the different agreements typically that you would find in the energy sector, both in the power sector, oil and gas sector. For the renewables, I think a week or two ago, we talked about a certain form of agreement that applies to renewables, emissions reduction purchase agreement. This is applicable within the carbon trading market system, where as an emission, where for instance, you want to, let's say as a company, as a green energy company, you have credits and you want to sell your credits to a company that needs credit in order to, in order to reduce how do I put it? In order to offset one's emission, if one is going beyond the allocated percentage allocated to a particular industry. So you can buy credits from a company that has more or excess credits to sell. You do that through by entering an emissions reduction purchase agreement. Having said that, so we have looked at typical agreements that you find both in the oil and gas, the power sector, or even the renewable sector. We also look at, now we go to the next slide. So we have seen the major contracts. The next one, we want to talk about the regulatory compliance bit. When we talk of contracting in the energy sector, what is compliance? Regulatory compliance is the process of complying with applicable laws, regulations, policies, and procedures, standards, and other rules issued by governments and regulatory bodies. What are the notable laws to comply with in the energy sector in Nigeria? First, next slide, please. First, we are, of course, the Constitution is the ground norm where all Okay. So first, the Nigerian Constitution, which, for instance, I think Section 44 tells us that mineral resources are the exclusive preserve of the federal government. I mean, so the Constitution is relevant. Even it talks of land ownership and all of those things, rights, which all affect how we contract within the energy industry. Then in the oil and gas industry, the petroleum industry, that's the Petroleum Industry Act, that's the primary legislation that regulates that sector right now. Before now, I mean, to some extent, we still have the Petroleum Act for some, to an extent, but before now, it was the Petroleum Act that governed every aspect of the petroleum industry. But now it's the Petroleum Industry Act of 2021. For the power sector, we have the Electricity Act. Before now, we had the ESPRA of 2005, but the Electricity Act has repealed that. General corporate governance, corporate commercial relay operations, you have the Companies and Allied Matters Act. And obviously, you have other related laws, but we are just looking at the primary laws. You can talk of the various tax codes, tax laws that apply to the energy industry. In addition, you have other subsidiary legislations published by the regulators. For instance, the NUPRC, they have several guidelines and regulations which have been released over time, a plethora of them on their website. Even the NERC, they also have a plethora of guidelines, regulations, orders released, and you can find them on their website, and policy directives. So all of these apply or regulate the energy industry. That is, we talk of both the petroleum industry, oil and gas, and the power sector. So what are the regulatory compliance strategies? So basically, regulatory compliance is just saying, hey, you just have to play by the rules, else you'll be sanctioned. I wouldn't want to take us into many of the examples where compliance defaults, cost companies so much in penalties. And not just in Nigeria, you even have situations abroad. Some of the times the fines they pay running into millions of dollars. So compliance is very important. If there's anything you joke with as an operator in the energy sector, compliance should not be one of those, because it takes just a little oversight or negligence for one to be caught up. So how do you ensure that you stay that you stay compliant to the laws as an operator in the energy industry or energy sector? First things first, as an operator, you have to understand the regulatory landscape. So if you are employed as a compliance officer in a company operating within the energy industry, your duty is to ensure that you are always current with regulatory provisions, update, amendments, because obviously in law, we know that ignorance is not an excuse. So there's need to stay updated and current with the regulatory landscape to know the changes, the things demanded or required of your company. Having said that, with regards to your operations, then the next thing, you determine your goals. When you want to carry out or embark on compliance, you have to ask yourself questions. Why, for what purpose, for what is the area of interest when you are carrying out compliance? Are you carrying out compliance because you want to avoid sanctions, or you are carrying out compliance because you want to make it the culture of the company? Are you carrying out compliance because you just want to do it for the formality of it? Or are you carrying out compliance because you want to make your employers see you as being very active, that you are doing something? What really is the goal? If the goal is, the goal should not just be about activity. The goal should be, first things first, the goal should be making compliance a culture of the firm. When you make compliance a culture, it's easier to look at the next goal, which is to abide or to stay or not to be caught up by sanctions, to always have a clean record. So if I were to be a compliance officer in a company, the goal for me would be to make it a culture of the company. Mind you, a compliant company, when you are compliant as an entity, it tells positively on your reputation. So it's not just about avoiding sanctions. It's not just about, avoiding sanctions. It's also about the reputation of your company. Imagine a company that is known to be used to paying bribes. It doesn't say good about the reputation of that company. Now, when you have identified your goals as a compliance person, within a company, there is need to train the other employees, or the company generally should ensure that the employees are trained in this regard. Trained in the sense that they should be able to inculcate in them the understanding or the knowledge of what it means to stay compliant regulatory wise, the activities that you should do as an employee, the things that you should not do. For instance, as an employee, one should be made to know that there are certain gifts you don't take from, let's say, a prospective or an existing customer of a particular company, because it might be seen to be an indirect way of bribing you, to gain favors. There are certain relationships or activities or conducts you must not be engaged with a regulator or even an employee of a regulator. For instance, an officer of, let's say, a regulator, I don't want to mention any name, comes to you to say, hey, this particular procedure needs to be done. However, if you give me this amount of money, don't worry, you'll be sorted. And you as a compliance person in an entity, or don't worry, if you give me this money, I'm in need now, I need to sort out this, and that. You just carelessly just give the money. You could be caught up as per bribing a public officer. And that would tell on the reputation or the record or the standing of your employer. So there's need for training of employees to understand the do's and don'ts. Now, implementing a robust compliance policies, and the need to share compliance responsibility across teams. In order to stay compliant as an entity, of course, there will be need to have policies, compliance policies. These are well documented by entities. So when you go to a place, a company, an entity as an employee, there should be a policy document that defines the do's and don'ts within that industry, within that company as an employee. And it should not just be a one-man thing. Compliance should be an everybody's responsibility within a company or entity. Because at the end of the day, the fact that the compliance officer knows it all does not absolve the company of any liability or responsibility if the cleaner, for instance, in that company engages in an illicit conduct using the name of the company, of some sort, linking the company to that illicit activity. It's still going to affect the company. So it should not be just a one-man affair or a particular compliance officer's, in quote, affair. The company should make it, spread across. So compliance responsibilities, like you said, it should not be a one-man business. They need to develop a monitoring framework and, monitoring compliance. You don't just, as an employer, say, oh, I have the policy. It's documented in the book. It's kept somewhere in the office. Oh, I'm complying. If they come tomorrow, I will show them. Oh, when I signed, when employing, the letter of employment, I've listed these requirements, this and that, and the employee signed when coming into the company. So I've done my own bit of the work. No, there's need to still develop a monitoring framework, because compliance is an everyday thing. It's not something that because I complied yesterday, today I'm fine. I can rely on past records. The fact that you complied yesterday one can be liable or can breach a regulatory framework that has just been published today, whereas yesterday the person was compliant. So it should be constant, a monitoring framework. That is why one of the strategies we said, adopting new technology. Technology helps in tracking compliance. So with that technology, you are able to know when there's a trigger to determine what to do. For instance, one way of monitoring can be introducing a whistleblowing policy within the company. So with the use of technology, there could be an anonymous reporting link where, let's say using Google Forms, where an employee who noticing something is about to happen wrongly in the company can just anonymously go log a complaint in and make a report without disclosing the person's identity. That helps in monitoring compliance. So yeah, monitoring framework should be set up. This can also be, technology can also help this. Adapting to regulations, this is part of understanding the regulatory landscape. Like we said, it should not just be about a one-off thing. There is need to adapt. Today, this law is there. Tomorrow, it can be amended. So as a company, as an operator in the industry, you should be able to always be 10 steps ahead, think proactively, knowing that, in fact, when the process is already kick-started for the amendment or enactment of a law, a company that is proactive would start thinking of the ways of transiting in case this framework comes into being. So let's say when the PIA, when the Petroleum Industry Bill was undergoing legislative process, obviously, as a proactive company, those days, there will be studies to say, look, if this act comes into place, A, B, and C scenarios will play out. How do we adapt in event this act comes into place? This would have been done ahead of time. So that's why you see companies that were prepared ahead of time will not be caught up by the changes. But companies that were not prepared ahead of time would struggle. So part of compliance is the need to adapt, and adapting here needs proactiveness. And last but not the least, prepare for audits. Obviously, the regulators will always come knocking. They always visit, or they will always come knocking to check your records, look at your books, and to know how you are faring. In that sense, let's say an NUPRC is coming to check another company's records. They need to always prepare ahead so that you are not caught up or you're not running helter-skelter in order to put things together. And sometimes you may miss a few details because compliance involves a lot. So there's need to always prepare for audits. Having said that, we have looked at the strategies. We just quickly rush through dispute resolution strategies. I realize that time is really running. Okay, so just to run down, notable dispute resolution strategies or mechanisms in the energy sector. We are talking of expert determination, negotiation, mediation, arbitration, litigation. These are typical dispute resolution strategies that you see in the energy sector. Let us just see the differences and their peculiarities. Please, next slide. For expert determination, is a private process. Sorry, the next one. So expert determination is a private process involving an independent technical expert. So in most cases, yeah, so their decisions are binding on technical issues rather than legal issues. They don't deal with legal issues. So let's say you are talking about what technical consideration example can I give now? Let's say an oil and gas, maybe a joint operating agreement. I hope this will make sense. A joint operating agreement, parties are in dispute over, let's say, participating interest over an asset or stuff like that. They can bring in a technical expert to decide on that particular issue. So you would say it is generally cheaper and time saving. However, it's not always the case. Let's say you are choosing a technical expert from London to come and resolve your dispute, because I've seen contracts like that, especially involving IOCs. Obviously, if you're not careful, you might end up even spending almost the same amount you spend for arbitration. You need to fly the technical expert down to Nigeria, for instance, lodge the technical expert in an exotic hotel. Their fees, depending on the institution that you are taking the technical experts from, So it's generally cheaper, but may not always be in all cases. And we also generally it's time saving, because obviously it's not such a very formal process. All you need is to bring in an expert and parties sit down and decide. Experts can make investigations and decisions independently. Because they are experts, they can make investigations and reach decisions without necessarily taking representations or relying on the position of the parties. And the expert determination process is confidential and private. For negotiation, this is often the first step towards dispute resolution. Simply, this time, there's no third party involved. So it allows the parties to just communicate their concerns and work together to find a solution that meets their needs. Most informal and time-saving, obviously. This party, you have issues, go to the other party, guys sit down on the round table and talk. Its success depends largely on the party's willingness to listen and compromise. So negotiation, obviously, because a third party is not involved, would need a lot of compromise if you have to reach an amicable solution. Each party may be represented by counsel if they want. Like you said, no neutral arbiter is involved. It is confidential. However, it's non-binding. It's just a negotiation process that you can't really go to enforce, unless you can actually just take that to a court, to reduce it to a consent judgment, and that will make it binding. But negotiation itself is a non-binding process. Mediation, it involves a neutral third party mediator facilitating discussions between the disputing parties to help them reach a mutually acceptable solution. So a third party is involved, an arbiter. It's actually a non-binding process, less formal than litigation and arbitration. Each party may be represented by counsel if they want. It's cheaper and time-saving, at least, than arbitration and litigation. Helps to preserve relationships, because obviously mediation for the parties to continue or maintain continue maintaining their relationship, mediation really helps. In arbitration, it involves also a third party, a neutral arbitrator. I use A, sometimes it could be more. So a neutral arbitrator or neutral arbitrators who would now listen to both sides and make binding decision on the dispute. More formal than others, but still less formal than litigation. But it's a binding process, generally quicker and cheaper than litigation. So because it's a binding process and cheaper and less formal, it's more patronized in energy contracts generally. So it's generally private and confidential. Each party may be represented by counsel. And in Nigeria, it's governed by the Arbitration and Conciliation Act of 2023, which is the regulatory framework, primary regulatory framework on that in Nigeria. Then lastly, litigation. This is, in most cases, the last resort when other options fail. In some cases, in some energy contracts, they really don't, after arbitration is the final process. They don't go to litigation. You know why? Litigation spoils relationships. It always leads to a winner takes it all outcome, which in some cases you might not really want. But yeah, and it's very time consuming and expensive. So it involves presenting the dispute before a judge or jury, who will then, like jury in this case, if you're in the US, or countries that practice the jury system, who will then decide based on evidence presented. So it's evidence-based. It's a binding process, generally not confidential. It's a public process. Because of all of these sensibilities, you see in energy contracts or commercial arrangements, parties more often go for arbitration. And parties are often represented by their respective counsel, even though obviously they can as well represent themselves. So we see that through these different options, each of them, they have their advantages and disadvantages, and depending, but in most cases, just to sum it up, you would see in energy contract, arbitration is always the most favorable approach, binding approach, in addition to expert determination, in some cases, negotiation, preceding the arbitration itself. So, but litigation is actually the least I've seen, approach used in or patronized in energy contracts, obviously because of these reasons. So having said that, I believe I've concluded my presentation. Please, if you have questions or comments, the floor is yours. Thank you.
All right, thank you so much, Mr. Ugbo, for that wonderful presentation from your end. It was nice hearing from you and you giving us a breakthrough on the concepts and everything that you had to share. Thank you so much, sir. So moving on, our two mentors are on call, right? So before we have Ms. Ugbo, please, we also would like to have Mr. Ayobami.
Hi, everyone. Dennis, please, I think you have my slide.
Yes, I do.
Okay, perfect. Thank you. So yeah, I mean, I know as the mentees on this call, we had to go around and get a lot of technical information for SafeWell on the risk strategies and the problems we have, the issues we have before getting to where we are right now, which some of you will think this is the best to know as lawyers. Yes. Today is talking about three very important things. We have contracts, compliance, dispute resolution, and I mean, to me, this is as good as having three different sections because it's quite wide. So what I tried to do yesterday when I was preparing the slide was to try and share my own personal experience over the first 4 years of my career working in law firms in Nigeria and England, and also the last 10 years working in multinationals in energy, oil and gas, power, and renewables. So basically, these are just practical things I believe that would help each other, our careers, basically as mentees also. Yeah. So going on, next slide, please. Next slide, please. So yes, first mentor has said a lot, so I'll be skipping quite a lot of things actually he has said, so that we won't overburden ourselves and would save some time. So yes, projects are driven basically for contracts, and when you hear contracts, it can be you're building something or installing something, a purchase, a service, or sale or consumption in energy, basically. Then, of course, regulatory compliance, we talk about the laws and regulations and policies that leads to approval, licenses, and permits. There was a time I was working on a regulatory compliance mandated by a multinational, and I had a software that had over 100 approvals, licenses, and permits required, for the oil and gas, particular oil and gas projects. So that's sometimes you have a lot, and the software it helps a lot because it prompts me 90 days before a license is going to expire. Then you start thinking about, it's time to put in an application for this license or the other. Yeah, and of course, these resolution mechanisms, just in case there's a dispute, which from time to time, of course, something always come up. Yeah, so there are various contractual templates where you hear about BIMCO for offshore energy. Then, the FIDIC has different, the ones for donkey projects, the ones for dredging, so a lot. Then you have logic templates also, depending on the particular you want to have. Yes. There are also various government agencies saddled with responsibility of giving approval and permits and licenses. You have the NDPLC, that's the Nigeria Upstream Regulatory Commission, the Downstream and the Midstream Regulatory Authority, and National Nigerian Electric Regulatory Commission, the NPC, National Council of Climate Change, Electric Commission of Nigeria, and TCN and others. Yes, next slide, please. So talking about the contract, first mentor, I said a lot about contracts. So, but these are particularly the contracts I've done some work in the past, so I won't overburden us with this. Then we also have in the power contracts, the oil and gas, the power contracts. You also given us some examples of it. Yes. So what I really want us to know about contracts, and this going down to practicality of this, is that there are some clauses that over the years have always been a usual hot topic when negotiating contracts, and I have some of them here, and I'll just give a quick download of that. Contractual prices, of course, most likely you have to depend on your commercial team for that, which is fine, yes. But on taxes has always been a big bonus, because first, the PIA brought in into a new tax regime, but also other contract, other taxes like company income tax, personal income tax, withholding tax, and VAT. And withholding tax can always be different from services and different for rentals and equipment buying. So it's two different things. I think services should be 5%, then rental and everything's like 10%. Yes. Then the VAT. Then we also hear about industry-specific taxes. We have, for example, the PIA introduced also the hydrocarbon taxes, basically, onshore and shallow offshore fields are paying like, I think 30%, and the onshore and shallow onshore marginal fields are paying like 15%. So, and of course, when it's deep offshore, then they are exempted from hydrocarbon tax, basically. So, yeah, then so you have also, talking about 1% Local Content Act, according to Local Content NCDMB Act, you hear that 1% is to be kept, then for that, then we're having any offshore, depending on most likely a rig or a vessel, you hear that something they call the cabotage tax, which is like 2%. So a good project manager in industry most likely knows that in his cost analysis and the cost engineer, his cost analysis, he needs to factor in all these taxes before getting his profits. So if you don't know about those taxes, then that means that most likely your profits is all going towards payment of other taxes. So that means, as lawyers also, you might not be financial experts, but you need to have an idea of what this is, and when you see them in contract, to be able to advise the party you're advising more appropriately. Yes. Then you hear about then of course for taxes also. I must add that we have seen in the industry some contracts have been broken into in-country and out-country scopes because of taxes. Yes. So because some services start and end in a foreign country, and then in Nigeria it starts and ends in another, but it's like a continuation basically. So you hear countries have two separate contracts. T and C's might be the same, but just for tax reasons, because if you lump them together, most likely you have to pay for things, for example, done in England or in Germany, as part of the tax in Nigeria, which wasn't a service done in Nigeria. So there are ways around. And of course, if you're bringing in, for example, in Nigeria, if you're bringing in bringing in subcontractors or contractors to work in the country, then you need to keep an eye on them being liable for company income tax also, and also personal income tax, depending on the number of days they're spending in the country. So that's what a Nigerian entity might be liable to pay, because most likely they don't know the foreign income entity, so most likely they'll come through to Nigerian entity to try and get the foreign entity. And usually the foreign entity just tell you that blankly that Nigerian taxes are yours, foreign taxes are mine. So you need to have that well detailed in your contracts here. Yeah. Then we're talking about indemnity, liabilities, and limitation of liabilities. Yes, indemnities, you hear a lot about things like mutual hold harmless and knock for knock, and so basically most templates will try and favor an equal in equal distribution of the rights and liabilities, in the sense that, for example, if there's a loss of equipment or a damage to the equipment, or there's a death or injury or anything happening, they want to exempt each other from those things, so that they won't be responsible for each other. Basically. Now, for example, I worked, there's a total contract whereby an ROV close to $8 million was close to $8 million went down into the sea from a vessel, and and of course there was indemnity provisions that holds total non-liable for that. So that's it. So you want to protect that if anything goes wrong and a personnel of another person, and also there's an equipment, you don't want to be responsible for that. So usually you see most people hold each other harmless from those kind of liabilities and indemnify each other. Yes. So the limitation of liabilities usually say that usually they'll tell you that anything that is wrong, the typical clause will tell you that anything that is wrong in a contract, liability wise, you want to cap it to a particular amount. Sometimes 20% of the contract price, sometimes 100% of the contract price. But usually over the years, contracting wise now, it's improved in the sense that now you see them having a carve out, excluding the cap for the limited liability. Like for example, now the cap is 100% of the contract price, but there's an exclusion for things like maybe intellectual property, maybe insurance monies gotten from insurance claims, for gross negligence and willful misconduct. You might see some exemptions for applicable laws, business ethics. So these are things that, if they happen, 100% is not enough to cover their liabilities. So it's important that you know what are the carve-outs that you want out, so that if those carve-outs happen, and then you know that you're not limited to the particular contract price or the percentage in the limited liability cap. Yes. Then insurance is also important. Yes. I mean, your personnel has to be insured, your equipment has to be insured. Then if you're working on a field or a project, you know that you have to have a comprehensive insurance, car, they call it car. Yes. And all that things, if you're using equipment, if you're using vehicles, if you're using vessels, you have to have a comprehensive, so that if anything goes wrong, you also know you have insurance claims to make. Like, for example, that total ROV that happened, there was insurance claim for it. I worked with the insurance brokers on that, and of course, there was a repayment by the insurance company after extensive investigations on what happened exactly. Yes, the financial securities here are important, because sometimes you have to give monies ahead, for example, and they call it advance payments guarantee or bonds. So that, for example, if I'm leasing monies before you have done your services, I want the advance payment guarantee to ensure that if you don't, the monies I gave you is secured, and if you don't do your services, I can take it to the bank and get my monies back. So also you hear of performance guarantees. You even hear of warranty guarantees, meaning that during the defect liability period or a warranty or a guarantee, you have something in place for security, just in case the other party runs away. Then you can go to the bank and take the monies and repair whatever you want to repair during those periods. Yes. So then also sometimes you, if I'm doing a business with a contractor and I'm not sure that he can do the work, or I'm not sure that, or I'm doing work for someone and I'm sure that he can pay me, I can ask for a letter of credit, meaning that I have something to hold if it's to pay me. So there are various financial securities in place. You have parents guarantee, parents complaint guarantees, also guaranteeing their subsidiaries and affiliated companies. So these are financial securities you put in place so that you won't, at the end of the day, for one reason or the other, you have something to gain by the financial security. Yes, termination clauses are very important. You also hear terminations for convenience, for default, sometimes for force majeure. Some people even do termination for non-payment, even though I always advise you should have a suspension in place before a termination for that. So for various reasons, yes, depending on what works for that particular company at a particular time, yes. Then warranty, guarantee, defect liability. Warranty is always done a lot for products, and guarantee is usually done mostly for services usually. And even though it can be used intertwined sometimes when services and products are together, yes. When defect liability says that, for example, while you're warranting and guaranteeing a product, if I buy products for you, a transformer, for example, for you in a power project, then you're able to guarantee to tell me that, oh, you can use this transformer for 24 months or 48 months. If anything happens, a defect that is not my fault, then you have to come in to either repair or replace. So there's always a particular period of time that after the contract has ended that you can always call on this person and say, oh, the transformer you gave me, it has a defect. It's not my fault. Then it's your fault. Then the other person comes in and repair, and then, or replace if you can repair. Then, of course, governing law and dispute resolution, I'll move that to discussion on dispute resolution, and then we take it there. Next slide, please. Yes, on the regulatory compliance, I mean, I've first I've spoken a lot on some of the laws, and so I just want to touch on some very quite important provisions in some of the laws. We have the PIA, and established the NPLC, that's the upstream, downstream, the midstream, and downstream, and upstream basically, then the midstream and downstream regulatory authority, then NNPC Limited. Yes, then of course it brought on new licensing regimes. The OMLs are changed to PMLs, the OPLs are changed to PPL, and basically it stands for petroleum exploration license, petroleum prospecting license. Then we have the mining lease, petroleum mining lease. Yes, so they brought in new licensing regime basically. Then the PIA also introduced royalties for onshore, shallow waters and frontier basins. Then we also have a new tax regime, like I spoke earlier. The complete income tax replaces the petroleum profit tax. Hydrocarbons are mainly for onshore and shallow offshore, and not deep offshore, which is exempted from the hydrocarbon taxes, basically. Then, of course, introduced the Host Community Development Fund, which is funded by 3% of the annual operating expenditure of that company. And the trust fund will have trustees that would guide how the fund is spent. But one of the interesting parts of this provision says that if after the community trust fund, which is very important, there's still maybe vandalization in a particular community, then this 3%, the money to be used to fix that vandalization, basically. So what you're trying to promote here is that if you are helping the community, then they shouldn't go around trying to disrupt my operations. Basically, that's what it's supposed to try and fix, like we used to have mostly in Niger Delta. Yes, and of course there's penalties and gas flare fees which will be the ministry would from time to time introduce, and then of course production incentives and the likes. Electricity Act also, it took the electricity off the exclusive list, so that now the states can now produce, transmit, and distribute power and issue licenses also for mini grids and power plants within a particular state. Then, of course, the whole idea was to also encourage renewable energy production, yes, and also to develop and there's also encourages that stakeholders should come together with the ministry and the NEC to develop an integrated electricity policy and strategic implementation plan. Last time I checked, this is still, I believe, would be under works, but it's still not yet released. Last time I checked, yes. And then the TCN also would, which is the National Commission of Nigeria, would also complement Nigeria also, which was sole a middleman between the generation companies, GENCOs, and the distribution companies you have in the various parts of Nigeria. So the TCN was its government that was handling all the getting the power from the GENCOs and distributing it to the DISCOs. So, but the TCN was said that we overburdened, and that's why sometimes we usually have a lot of crashing in the national grid. Yes, because the GENCOs claim that they can make a whole lot more power, but the capacity of TCN to receive the power is limited, meaning that we are producing more, but we can't transmit and distribute as much as we can produce. So meaning that TCN needs supporting partners in that industry, and of course private sectors to be involved in that. So the law allows for private sectors, but it's basically based on if TCN requests the particular region or not, they're having some issues. So, but yes, it's better than the previous law, which it gives all the authority to the TCN alone. Yes. Also, there's an interesting part of the law of the Electricity Act that says that that private individuals can own electricity, can generate electricity no more than 1 megawatts at a site, and for private use, for example, and of course, they can still distribute not exceeding 1 kilowatts without a license, and they're subject to next issuance guidelines, basically. Yes, also, I think some weeks ago we spoke about National Energy Transmission Plan, so I won't say much about it, but it's just basically to generate new funding and investment opportunities and in achieving our carbon neutrality between 2070, basically. Next slide, please. Yes, and also we have the Climate Change Act, which was in 2021, which I still feel is more of a document than it's been used in practice, basically. And it talks about how Nigeria would meet the 2070 goal in carbon neutrality. Yes, I mean, it provides that for example, each company that has more than 50 employees should have an employee sustainable officer, and to give you annual reporting, to the National Council of Climate Change. And every government agency should also have a climate change desk, and there'll be sanctions for the principal officers if there's any issue. Then, of course, introduction of carbon tax and emission trade changes and a climate change fund, because apparently, I think Nigeria will need close to $400 million if Nigeria is going to meet its target 2060. So climate change fund will be more from donations and then carbon taxes, emission trading, fines and charges resulting from non-compliance with the Climate Change Act. Of course, there's also other local content laws in Nigeria, SCDB for the industry, the cabotage, which takes care of offshore operations and vessel related, administered by the Nigeria Administration of Maritime Administration and Safety Agency, NEMASA. And we also have one for the power sector, National Content for Development, which is a regulation that the NEC would from time to time can issue out. And we also have other restrictions and government policies and guidelines released frequently by ministries and departments and agencies of government. Yes. Next slide, please. Yes, on dispute resolution. Yes, our first speaker spoke a lot, especially relations to the table on an alternative dispute resolution. Yes, but I always say in litigation, most people do litigation because they feel that it's less expensive. But the fact is that usually the way our court system is overloaded with cases and not enough number of judges, then you have a long duration being used. And even though the expenses are still it's not as much as we have alternative dispute resolution. And jurisdiction also is very important that in our contracting we get jurisdiction rights, in the sense that both parties need to agree on which jurisdiction they are submitting themselves to in case of a dispute resolution. And if they don't, then it becomes an issue in courts to try and prove that a particular jurisdiction is the right jurisdiction. And sometimes the court will look at the places of the parties where they have their head offices or where they have their major offices. The court sometimes will look at the place that particular service or work was done, and some other reasons why the court might not want to use to narrow down a jurisdiction. So to leave that just open-ended, it's better when both parties are specific about it, especially in their contracting, so that there won't be any ambiguity at all. Yes. On the alternative resolution, yes, the Nigerian Arbitration Conciliation Act was changed recently by the Nigerian Arbitration Mediation Act 2023, and then we have the following kinds of arbitration, ADR, arbitration, mediation, negotiation, conciliation, and these are things that our previous mentors have spoken about, so I just move quickly. Yes, of course, expenses, yeah, they are pretty much expensive than litigation. I was once, I think, just pre-COVID, I was involved in the ADR, and the cost was pretty much, I think, like close to like $6 million USD or thereabout, and it was because the claim there for that particular was close to it was $99 million of the claim. Yes, so yes, they can be quite expensive. Yes, especially depending on the body. I believe the Lagos multi-door courthouse is still one of the cheapest around. Yes, yeah, but others are I'd be more expensive than they are. Yes, the duration are always faster, and it's always a more of not as strictly formal like we have in litigation, and so there are rules, and as long as you obey the rules, and you do the necessary things on the rules, then you're fine and good to go. Yes. So this is always more encouraging contracting, because it's faster and it can be kept more confidential than litigation, basically. Yes. And the next segment is talking about, yes, Lagos Court has spoken about this. We also have the Lagos Court of Arbitration, and most states now are having their multi-door court houses, so that's good. Yes, but you see more of the multinationals use a lot of London International Court of Arbitration, and in Asia, Singapore is becoming one of the fastest growing alternative resolution centers in the world. This SIAC, they call it SAIC. Yes, and they also their laws are still favorable, so you also see their laws being used as part of one of the common law jurisdictions. Yes, so in Asia, most Asian partners always want to use Singapore, while most other Western countries always want to use London or sometimes Switzerland, actually. Yes. And why it is very important that it's specific in contracting, because you don't want to have, if you don't mention governing law and don't mention a specific this resolution mechanism, then you're leaving it out for a lot of interpretations. And you might see multiple litigation or multiple ADR in multiple countries just because there's a lack of specificity in a particular contracting. So it's very important that it must be clear which governing law, which rules you want to depend on, where exactly, the language, are you sharing costs, then also give a room for injunctive reliefs, meaning that pending the application, for example, if I need to get an injunction to stop a ongoing thing, then I can always go to court also. Why? But just to stop it, why we pursue the ADR mechanism we want to go to. Then why are we doing that? Is because forum shopping is real. Forum shopping is when you go around looking for a court or a body that would give a favorable response. And why I have forum shopping, the next line talks about law of England and Wales, which is an example of forum shopping. I'm of the opinion, which I know some of my colleagues have always argued this about me, that but having worked in England and practiced in England law firms and law firm and complaints, I always say that the difference between the law of England and Wales. You hear a lot of law of England and Wales or law of the UK. So is that correct or not? That's left for you to decide. But I always say that either you go with the law of England and law of Wales. Why? Because both have the parliament also make their own laws. So while we might have some laws that govern both England and Wales, there's also specific laws that govern England alone and Wales alone. So if peradventure a dispute is going to be under a law that governs England and Wales, that individually, then that means I will choose which one is favorable to me. If Wales is favorable to me, I'll go. The other party might say, no, I don't want to favor the other party and let me go to England. They already have a foreign shopping ambiguity in place. So I always advise to avoid this, whether you choose the law of England alone or law of Wales, or the law of England and Wales, so that you help yourself and not create ambiguity and dispute resolution. So also it's also important that a lot of contracts in Nigeria, which is not encouraged by the local content, or the local content will list you that you should try and use Nigerian law. But the fact remains that international transactions, they always see a lot of these laws coming up, that are foreign laws, basically. And it's important that just to say, oh, law of England, and I sign to it without knowing what the law says. So it's important that you have a grasp of the governing law, And I was reviewing some contracts with some Germans some days ago, and the laws was law of England. And anyway, transaction is not a Nigerian transaction, by the way. So, and one party, there was a firm I thought was unfair, and it was insisting, and my mind went back to the UK Unfair Contract Terms Act, meaning that there's some terms that you can agree to, and the UK law will say like, oh, it's unfair, So if you don't know that, and you just say, oh, law of England, oh, it looks tush, better than law of Nigeria. And that's what you might think. And end of the day, you sign up to it without having a grasp of the governing law. So it's important that any governing law you outside Nigeria, hopefully, meaning that we expect you to at least know a bit about Nigerian law. And in law outside Nigeria, it's very important that you know that law you're signing up to, or else you might sign up to something that you didn't expect. Yes, then I spoke about injunction relief already. And enforcement also, yes. So it's always good to have a room in the clause that allows you to enforce any judgment or any arbitrary awards anywhere in the world. You know, there was a funny example of that happened that whereby the party took a decision that went to enforce a maritime claim in Las Palmas, Spain. You know, just because it could do that. So it's important that you want to have a wide coverage of enforcement so that any asset you're looking for or the other party that you want to lay a claim on, you can easily go approach the law court in that country and impute your award or your judgment so that you can get an enforcement of it. But it's also important to note that international treaties should be in place because there's some laws, some countries that will reject your enforcement because there's no mutual treaties being signed by both countries or treaties are not signed under the UN conventions like that. So it's important to know that which country I can make an enforcement in and also have provisions for that in our contracts. Next slide, please. Yes, so conclusion, and so it's important that we have a proper grasp of the contract and resolution and regulation compliance we have in a particular project so that we can mitigate risk involved. So because these three things are things that actually bankrupt a company or make a company cease to exist because, for example, regulatory compliance can expose you to fines, and we've seen a lot of multinationals being fined for how they do the business in Nigeria. Yeah, so it's important that we note that these three things are very important. And as a lawyer, we need to pay good attention to understanding these three things for our career as a lawyer, especially in the corporate commercial sector. So thank you so much. Yeah, take it. Bye.
All right, thank you very much, sir. We really do appreciate that presentation from your end. We thoroughly enjoyed it. Thank you so much, sir. Back over now to our last but not least of our mentors for today. And I think for the first time in this quarter, Ms. Obo, thank you so much for joining us. Please, we would just like to receive the presentation lastly from your end so that we can go over to our mentees. So please, I also like to kindly encourage the mentees to prepare for their presentation immediately Ms. Obo is done so that we can take your presentations and get feedback from the mentors. Ms. Obo, are you with us?
Yes, I am. Hello, good afternoon, everyone.
Yes, good afternoon, ma. You're welcome. Thank you for joining in.
Yeah, thank you. Thanks for the opportunity. This quarter has really been so choked up for me. So apologies for not making the first session I initially signed up to attend. And then I'm wondering at this point, what do I have to say? Boho, Ian, and Precious. Yeah, like you guys have killed it. You know, you've actually gone into a lot of detail, you know, on the particular subject we're looking at. So honestly, I wouldn't want to go into all the issues that you've already spoken about. What I'll just try to do would be to maybe throw some light on some areas that you have discussed and then just share some of the issues I feel are trending right now in the sector that I felt just be important discussion points to highlight. And then we can make our own conclusions on how we want to look at those issues. So thank you once again, Boho, Ian, and Precious Yola. It was fantastic. I wouldn't mind getting those slides. Really very, very informative. I sent my slide across, but I'm not really going to go into the details. So on the contract bits, we've had the two previous mentors walk us through the asset acquisition contracts, the different kinds of contracts that parties will enter into to get a slice of the oil and gas. Sorry, just by way of background, my background is in the oil and gas. So I work in-house counsel or company secretary to an upstream company. So my experience is more in oil and gas upstream and midstream to an extent. So most of my comments or examples will be around issues along that spectrum. Yeah, so the point I'm just going to make on this, practically speaking, is you find a lot of people who say they have, oil and gas assets. So you can get into, the business with any of these contracts. It's important as lawyers or as commercial people to understand how these contracts work. But I feel one thing that's standing out to me now is that the real thing or the real issue is the financing aspect. So in getting into this commercial arrangements for asset acquisition, you realize that you just pick a template, or this is the AIPN model, or this is a standard template that this person has used for this concession contract or this GOA or this FTSA. And you're not really thinking that on the back of these acquisition contracts are financing arrangements that you have to pay particular attention to, because people have, again, so many companies or individuals have oil blocks, assets, but they're not earning $1 from those assets. Not just for several reasons, but a lot of time, the problem is that those contracts they have are not contracts that are commercially viable. So how it's important for you to consider how the commercial or the contractual construct of that particular asset acquisition contract allows you or allows your assets to be attractive to financing. And I know that in previous weeks, we've been talking about energy transition. Of course, I have my views around how we should approach energy transition as a country, as Africans, and what we should be doing in this season where the world is all about energy transition. So we are already in a situation where we already have issues with securing finance. So at the very least, as an oil and gas operator or someone who has an oil and gas asset, you now have to make sure that your foundational contract or whatever commercial construct, contract is giving you access into that space is something that is attractive to the lenders. So that's something I just wanted to highlight on oil and gas contracts. Another point I wanted to make, which Precious spoke about, he was talking about governing laws and applicable laws and the law of England and Wales or the law of England, and I found that really interesting. But the practical point I want to highlight there is, for example, I'm only qualified to practice law in Nigeria, so I can't advise the client on English law. So, and I've had some clients approach me, to say, oh, look at this contract or review this and let me get your thoughts. And I'm always very quick to say, I can advise you general principles because in a way, some of our laws, are similar. Some principles of law, cut across multiple jurisdictions, but you'll be surprised at the point of, divergence. You'll be really surprised. So it's very important to highlight to anybody who is asking you to advise on a contract that's governed by the law of England or the law of England and Wales. You need to be very clear to state that you're not qualified to advise on an English law contract. So if the budget for that particular project permits, by all means, get English counsel. They don't come cheap. In Nigeria, the lawyers are really cheap. When you want to engage English counsel for your project and you're talking millions, then you understand that you're probably working in the wrong jurisdiction. So if your budget permits, by all means, please get English counsel or get, qualified English counsel. And if you have the capacity, please take the bar, go to these other jurisdictions that are really popular, London, New York, take the bar in those jurisdictions and get qualified. Then another thing I also wanted to point out, Uboho really went through, he gave us like a very detailed breakdown on the different contracts, and he really went in depth. And one thing I've also realized is, and I know they teach us this in law school, there's something about when you title your contract, for example, a service contract, but it's in actual fact, it's not a service contract, it's something, entirely different, So from my experience, I've seen situations where you now have like a hybrid, so one contract form slips into another, and you take the good points from this contract and you take the good points from another contract and you merge it together, and then it becomes something that works for the parties, under a particular commercial arrangement. So as much as it's important to understand these distinctions, you shouldn't also be surprised when you find contracts that don't necessarily, fit the exact mode or principles that this service contract or this rig service contract, or this productions and sharing contract, or this FTFA. Sometimes people might name a contract, along a certain, broad term, but when you look into the details, you start seeing, different formulations. And just for example, recently I've had to advise on some financial and technical service agreement, FTSA. And FTSA I've seen is, will I say, one model that people are using or companies are using to actually get in the game without going into the emotional negotiation of getting actual rights, in the asset. So you're telling the owner of the asset, don't worry, you're still the owner of this asset. I don't want you to give me 40% equity in this asset or 30% or whatever. Just keep your asset. What I'm going to do is I'm going to come in, I'm going to provide financial services. In other words, I'm going to fund the development of this asset, and I'm going to provide technical services. So even though I'm funding, I'm kind of paying myself to get the work done, usually maybe with a company that has the technical expertise or some kind of alliance with like the big technical firms that service, oil and gas, the oil and gas industry. So I'm giving that example to say you would see even among FTSAs that there is really no standard. You see some FTSAs where the service provider takes crude, where he has some form of forward sale arrangement and he actually gets ownership of the crude. You see some FTSAs where the service provider has no line of sight to the crude, and the only thing he gets is, something under the waterfall in terms of like cash, when the crude is sold. So the point I'm trying to make here is we have this broad, contract regime with different kinds of contracts, and we could name them a certain way, but don't be thrown off, when one principle in one particular kind of contract spills into another contract. It's usually a function of how the parties have decided to structure their arrangement. It might also be a function of the financial structure that they're using to finance the particular deal and what the lenders have said, I need this, I need that, and then they structure the acquisition along those lines. So that's another point I wanted to make. Then on the issue of compliance, again, a lot was said about compliance. And in-house, it was interesting when Precious talked about a project where he had at least 100 laws, or was it compliance action items? I wasn't sure. And I laughed, while listening to that, because that's so true. And the way I look at it, in this business, everybody's your potential regulator, rightly or wrongly, everybody's your potential regulator. And I always say somebody in some regulatory agency, maybe what's that industry ministry that does town planning or forestry? And someone is just in their office and they're like, we need some action in this department. What do we do? Let's write to this oil company and tell them that according to this law, all the trees they planted in their facility, we have regulatory oversight. And before you know it, they are asking you for the list of all the number of trees in your facility. They're asking you for this, and that's significant management time that you now have to devote to dealing with this regulatory requirement. So for me, I do not think you're in the business to comply with all laws. If you want to comply, and this is my personal view from experience, if you want to comply with all laws, you will not be able to do business. You will not be able to do business. What I always aim for is substantial compliance. What I always aim for is engagement, continuous engagement with your regulators. Because, for example, you have financial commitments. You need to pay your staff salaries, you need to pay their pension, you need to pay their healthcare, you need to pay your contractors, you need to pay your taxes, you need to pay so many other regulatory fees, you need to pay your contractors, you need to pay operating. There's so many things that are demanding for your financial resources as a company. And if you go about and your objective every day is to make sure you're 100% compliant, you won't be in business. So you now need to play a balancing, game to say, okay, this is the nature of my business. What is most important to me? For me, I would say I need to make sure that my employees are happy, because those are the guys that would ensure continuous operation. So you set aside employee compliance issues as critical. You can say NUPRC is a very difficult regulator. If I don't comply with NUPRC standards or guidelines or their regulations, they'll just shut down my field. And once they shut down my field, I would not have the income I need to, keep the show going. So I'll make sure, what are those key NUPRC requirements, and make sure I satisfy them. Okay, NCBMB, oh, they could be a thorn in the flesh. What do I need to do? How do I handle NCBMB? Because if I don't comply, they can hit me with a 5% penalty, for the very thing that I couldn't do in the first place. What do I do about that? So you have to, it's a balancing act. I think that's just the point I wanted to make about regulatory compliance. Just like the Boho said, it's important for us to have a culture as an organization that we're going to comply. But the balance there, I cannot comply with every law. So I need to be strategic. I need to understand, okay, I'll pay my employees now, then later I'll get some extra funds, I'll pay my taxes. Maybe I won't pay everything at once. I'll have a discussion with the regulator. Can I have a payment plan? Okay, tells me you with a payment plan. You have another discussion with your community. Can you come up with this procedure so that I can pay you? You don't have the money to pay yet, but you put in, you be strategic about it, and you'd have to, you have to find a way to be creative, really, if you're going to survive in the business. Because if you're the lawyer that doesn't really understand that as much as there are laws to be complied with, there's a business that, needs to be run. There's a business that needs to keep being a going concern. I think it's just important for us to always balance that. But the key point there is continuous engagement. A regulator sends you a letter. Don't just say, oh, they told me at that JIIPCC meeting that we can't comply with every law. You have to continuously engage. You send a reply, oh, we're working on you, we're putting in, measures to make sure we comply. This is what we're doing. As much as possible, if you can demonstrate, those steps that you're taking, go ahead and demonstrate it. But let the communication lines between you and your regulator, let them be open continually. And in my experience, I've seen that regulators, at least the good ones, the ones that are commercial, they actually understand, the difficulties that operators face in this business. And if you're open and you're communicating, they would actually find a way to help you, because if you stay in business, it's good for you and it's good for them as well. Two more things I will just touch on. I think I had a slide here around this domestic crude oil supply obligation. And I thought it was important to have that discussion because it's something that is, it's something that as a company, for example, we're in the middle of how we can structure our operations to satisfy, this particular obligation that's in the PIA. So, Baho was talking about the fact that, as a company, when we've had like series of discussions around the fact that, there's a new law coming, you have to be proactive and all that. But short matter is, yeah, you should be proactive, and it's important to get your company ready for change. But there are some issues that are so fundamental to the way your business is run that you just have to wait for those issues to come, and then you now have those engagements. And for us, I think this compliance with domestic crude oil supply obligations is one of them, because usually in this business, a lot of us are leveraged. And what do we leverage on? What is the basis for the loans we take? It's the crude. So a lot of us have like prepayments, the crude that we're going to produce for the next 5-10 years. We've sold it to a particular lender, and we've already designed, our entire business model, along a certain, commercial understanding. So where a crude oil supply obligation comes in, it changes the entire landscape. And yes, the law says that all operators would have this obligation to supply crude oil to the local market. That's to refiners like the Dangotes of Nigeria currently. But the issue is we already have these existing, commercial obligations to other parties. Now, the government will say it doesn't really matter, what existing commercial arrangements. This supply obligation is a form of fulfillment. In other words, just take it that anything you are supplying to the local market is something that you can't export or you can't sell. With that kind of arrangement, you're already making your investors, a big concern about certainty of law. You're already making them a big concern about whether this is actually, an environment they want to come in. Remember, you said we're already in an energy transition environment. So those are some of the issues that we're dealing with. So I wrote there again, the principle of willing seller, supplier, willing buyer. The PIA says that, yes, you have a crude oil supply obligation to the domestic market, but it has to be on the principle of willing seller and willing buyer. But it almost appears, at least speaking from an operator's perspective, that it is not necessarily a willing seller and a willing buyer. So you have big buyers, that want to buy on their own terms and do not want to understand that if I've already sold my crude to a particular person in advance, and I've said, I'm going to get this crude, or my loan is being serviced in USD, I can't pay you can't be paying me for that crude in Naira, because my existing obligations require me to repay my lender in USD. And this whole Naira dollar volatility is bad for business, So those are some of the issues. So another issue we're currently dealing with is some people believe that, this is something operators need to do for the country. It is in national interest for, you know, those who are in the upstream to deliver crude to our local refineries so that the cost of petrol can drop from 1,000 naira to maybe 500 or something. And, you know, there's that narrative out there. But people also don't consider that before you set out to, you know, invest that much in a refinery, the first thing you should have considered from a commercial aspect was your feedstock. You should have like long-term contracts, the same way we have long-term contracts where that we've leveraged on to develop our upstream. If you're also going to build, you know, a refinery, you should also have those engagements and lock in those supply contracts in the long term. So we also need to consider if this crude is supplied, you know, eventually to these local refineries based on the commercial construct that's available internationally, being that crude is an international product, is that really going to automatically translate into, you know, a low cost of PMS? I think it's something that, you know, we need to think about. Also, these refineries, do they really have the capacity to pay? Is an upstream company that is leveraged, that has bills to pay, are they going to take the risk, you know, of paying, of selling crude to a domestic company that is not going to back it up with like foreign LC, that's not going to back it up, you know? I think it was Precious that was talking about payment securities as being part of the important considerations in the contract. In this kind of contract, it's very critical. So these are just some of the concerns that I think operators have, and somehow the conversations that I've heard so far, people don't really, you know, have those conversations, and it's just about, oh, if we're not, if food is supplied to this person, or all the problems in Nigeria, you know, it's going to be over as relates to the price of PMS. I think time will tell, but is it important for us to boost our local refining capacity? I think it is. Was that the reason behind this crude oil supply obligation? Yes, it was. Initially, it was just that we had with gas commercialization programs and all that. Yeah, but now it's important for us to actually develop our midstream and our downstream so that we would not be a country that's producing crude, and then what we are gaining on the upstream, we are losing it in the midstream and the downstream. So those were just that's just the second to the last point I wanted to make. The last point is just by way of information. So I don't know if any of us have any experience with Logic JQS. So Logic JQS it's like a portal that NCDMB, that's the Nigerian Content Development and Monitoring Board, that deals with developing local content and making sure that Nigerians or Nigerian companies have the opportunity to participate in the oil and gas sector. So they have a portal, and as individuals, you can go on that portal, register, and when there are training opportunities or when there are job opportunities in the industry, you might be shortlisted. We've had situations recently in our company where we had to carry out, because capacity development is also part of the project that oil and gas companies are meant to do by law. And we have consultants that go into, you know, the Logic JQS portal and shortlist candidates that can actually take advantage of, that can take part in these trainings that oil and gas companies. So it is not something you've done. So I've not done it personally, but I know for a fact that our company, we've had our consultants go into that pool to get candidates to train in different aspects of oil and gas business. So those are my final thoughts and final words. Again, thanks a lot to the mentors and thanks a lot to the mentees for giving us this opportunity. Thank you.
Thank you so much, Ms. Obo, for that very interesting session from you. We really do appreciate your thoughts and everything that you have said in class. Thank you so much. Seeing that we are far spent on time, we'll be taking quickly our presentations. Please, group one and group two, please group one, kindly start your presentation. You have 7 minutes for presentation. Group two, also get ready to make your presentation immediately, and then we'll take feedbacks and questions from the mentors.
Good afternoon, everybody. I would be taking the presentation for group one. So our topic, energy contracts. Can everybody hear me?
Yes, we can hear you.
Okay, so our topic was on energy contracts, and with the way the energy industry is going forward, it has actually made a lot of people think about how to come up with an agreement that would serve both parties. That is the contractor and then the purchaser or the supplier or something. So for energy contracts, they are tailored similarly to that of the normal agreements that we are used to, but there are different types of clauses that are inside an energy contract, which we'll get to know as the presentation goes on. So the first question is, what is an energy contract? And then types of energy contracts, and then strategy, significance of compliance, how to draft, regulation, and dispute resolution. An energy contract is an agreement between two or more parties involved in production, distribution, or consumption of energy. Now, there are multiple parties, or it can just be two or more parties, but what the contract aims to do is to make sure there is an understanding between both parties or multiple parties as to what is expected of each person. And it also outlines the terms and conditions, what are supposed to be done, what is not supposed to be done, what would happen if one person breaches the contract, what will happen if both parties breach the contract in the case of the death of a contractor or something. This is basically what the energy contract is all about. Now, there are different types of energy contracts, but I'll just be listing a few. We have the power purchase agreement, the energy supply agreement, the transmission services agreement, the gas supply agreement, and the renewable energy credits. Now, the power purchase agreement is an agreement between a generator and a purchaser. Now, a generator is someone that actually generates electricity. They are the people that produce the electricity that they now sell to suppliers, which can be the government, which can be the utility company, which can be any large company that distributes electricity. Then energy supply agreement, it's between a supplier and a consumer. Now, this supplier, for example, now like the Power Holding Company of Nigeria, which we now have that is separated into discos, they are the suppliers. Gencos, thank you. They are the suppliers. The Gencos are the suppliers that buy from these generators. The Gencos are generators, and then the discos are the suppliers. Now, energy supply agreement is it can be between the government and a household. It can be between AEDC, for example, for those of us in Abuja, between AEDC and a private individual. Now, a transmission services agreement is between a transmitter and a receiver. That is a utility company and a generator. A gas supply agreement is between a gas producer and a purchaser. Now, a gas supply agreement, since Nigeria is moving into CNG, we're going to see more of this come up because Nigerians are tilting towards the aspect of CNG, that's gas-powered cars, and there will have to be so many agreements that will come up. Yeah, CNG, compressed natural gas, and then private individuals. Now, for this gas supply agreement, it's between a gas supply company, case in point, let's say NNPC now. They are the producers of gas, and then a purchaser. let's say, another fuel station. So this fuel station comes from their own end and they buy from NNPC, and then there has to be an agreement between both parties. And then the last one is renewable energy credit. Now, this is also a new one because people are moving into renewable energy. It shows how much a person, because now that the Electricity Act has actually allowed people to generate their own electricity up to 1 megawatt. So this will show how much credit a person has before he or she can purchase power from the renewable energy suppliers. And then there are different contractual agreements that actually exist in the petroleum and energy industries, and they extend to concession, joint venture agreements, production sharing, service contracts, farm in, farm out, technical assistance. Now, for something like the farm in and the farm out, it's an agreement between parties where one person wants to use another person's property to farm electricity, or you want to what's the word now? You want to use the resources of one person to generate your own electricity. Joint venture agreements. Now, a joint venture agreement is something that is commonly used in Nigeria. They are used a whole lot. But because of the way production works in Nigeria, it's actually very difficult to have a joint venture agreement under energy law. Joint venture, they actually work better for real estate because these are properties that you can see. Energy is something that you cannot see. Yeah. So if you want to use a joint venture agreement for energy, it means one person would have to maybe drop his house or his land, and then another person will not have to buy the equipment that are needed and put on the same land. Another person comes with this, and another person comes with that. Each person is bringing in their own property and expertise to come together and make sure that these agreements work hand in hand. But again, it is something that would have to be checked out properly for it to work effectively for energy law. And then production sharing contract. It's an agreement where a foreign firm and the government share the output of operation. Now, a foreign company can come into Nigeria and say they want to generate electricity for Nigeria, or they want to use our resources, or they want to give us different forms of energy. For example, oil, since crude oil is a major thing that we use, oil and gas. Now, this foreign company can say, okay, we will bring in foreign expertise, we will bring in equipment, you have the oil. We are the ones that are coming to mine this oil. We are going to refine it. And then when we sell it, this is how much we are going to take. This is how much we are going to give you. These agreements, it's actually something that works currently in Nigeria because we do not refine our crude oil. We actually export it and then re-import it back. Now, when we are importing it back, or when we are getting our own fair share, the people that refine it are the ones that get a higher concession because they are the ones using their time, energy, and resources to refine crude oil into petrol, diesel, kerosene, and the rest. And we are just the ones supplying the oil. So we have a lower output and they have a higher output or percentage. And then there are also regulatory compliances that Nigeria is supposed to do. We are supposed to be like the Electricity Act now is the major law for energy in Nigeria. It covers renewable energy, it covers fossil fuel energy and the rest. And for companies that want to go into energy, they have to be compliant with the laws. Now, like our mentors have said, there are so many laws or so many regulations that companies have to go through. Aside the electricity part, they also have to go through environmental checks. They have to make sure that they are labor compliant, that's their compliance with the labor laws and everything. Now, these are the various compliance strategies that they have. Risk assessments. The companies that want to go into energy law or are currently into energy law have to check for risks and how to mitigate this risk when they come up. For example, now someone wants to start up a wind farm in Nigeria. Because these things are very large and they actually they make use of the wind a lot, they have to check to see, oh, will this thing affect the weather condition of this area? Will it at any point collapse and affect people if it's a residential area? What happens when this happens? What should we do? And so on and so forth. And then due diligence. They have to check properly. They have to be very sure that every single thing that the government of the country they are in has given them to do, they actually do it. The contract management, they have to make sure that all contracts signed are okay. You can't just wake up and sign a contract and then you find out later that, oh, a clause is going to indict your company or something. You have to make sure, yeah, it's still under due diligence, but you have to make sure that everything works hand in hand. And then trainings and awareness, this cannot be overemphasized because you are coming to work with people. You have to train them on what to do, how to do it. Or if there's a fire outbreak, what to do, how to manage the equipment, how to use them properly and all that. Now, the significance of this is it ensures adherence to legal and regulatory requirements because when you are regulatory compliant, it's a plus for you. The government will not be after you. They would not come to lock down your office. They wouldn't treat you like or something. And then it also increases productivity. Yeah. Because when your people are happy, when your teammates or your employees are actually working in a company that is not being chased down by the government, they would want to give in their all. When labor law practices are used, they would want to ensure that, oh, because the company takes care of me, I would want to take care of the company back. It mitigates risk of non-compliance. That is, they won't be fined lurking around. You can't just, the government or the people in charge will not just wake up one morning and fine the company for one thing or the other because they are regulatory compliant. And then it facilitates transparency and accountability. Now, the company will be able to make profits. They will be accountable for everything, and it's not look like they are being what's the word now? They are being shady to their board of directors. It supports the reliability and integrity of energy markets. It encourages sustainable and responsible energy practices. We'll also talk about the best practices for dispute resolution. Dispute is bound to happen at any point in time, but it also means that there are ways in which these disputes can be settled. Now, clear communication. All the
Hello,
parties have
Christabel.
to be
Can you hear
open.
me?
Yeah, I can hear you.
Yeah, sorry to cut in, but then please, we would like to kindly ask if you can start rounding up the presentation. Thank you.
No problem. So best practices, clear communication, early intervention, documentation, expert involvement, and engaging subject matters. So the next one is how to draft an effective energy contract. The first one is to identify all the parties and their roles, define the key terms, specify contract duration, outline energy supply and delivery obligations, address compliance with relevant energy regulations, include dispute resolution mechanisms, and consider adding provisions for force majeure, confidentiality, and indemnification. Now, energy contracts require a lot of work, and they also require the eagle eye to make sure that both parties are not sidelined and every party would actually work together to make sure that the contract, when signed, would be honored. Thank you.
Thank you very much for that wonderful presentation from your end. Thanks to you and to your group members for putting together that presentation. It was well delivered, well done, and we'll be getting feedbacks from our mentors after group 2 is done. So group 2, please, if you are ready for your presentation, please, you can kindly start so that we can move on with what is left of class.
Okay, good afternoon, everyone.
Yes, good afternoon, Tommy.
Yes, so sorry, before I start, should I share the slides or would you share
Yes.
it?
No, please try and share your slides. And please take notes, please. You can do your presentation in 7 minutes. Thank you.
Okay, sir. Okay, So sorry, sir. I'm trying to share my screen so I could start. Okay, good afternoon, everybody. My name is Adesola Tonisin, and I am the presenter for Group 2. So our topic that was given to us was enhancing energy contracts, compliance, and dispute resolution strategies. However, we did not focus on the same key points as Group 1. So I'll first start with, energy contract, as our mentors they said earlier that energy projects are driven by contracts, and it could energy contract could either be for building, purchase, or services. And an energy contract is just basically a legal agreement between two parties, that is the energy and the provider. However, in the course of transactions, it's not always impossible to always avoid disputes. Disputes will always arise. It could either be as a result of lack of communication, or just maybe there was not enough clarity in the terms. So in order to avoid this, there are some preemptive measures to avoid for such disputes. And number one is clear and comprehensive contract drafting. The contract should be well drafted. The scope of work, it just has to do with the area in which the agreement focuses on. If the agreement is for building, then the scope of work should not be in relation to something that it's not why that contract was made. Then we also have for the regulatory compliance and permits. As we've mentioned, they need to talk about the contract should for the purposes of the contract, there should be regulatory compliance. So let's say, for example, if the contract is based on captive power generation, the party who is meant to get the license from NERC to ensure that he has the proper permit to give to an off-taker whatever amount of megawatts that off-taker intends to buy, which should also be stated in the contract. Then we also have risk allocation and management. In part of the terms of the contract, it needs to be specified which party would take which risk, which party, in case this happens, which party would be in charge of this, force major clauses, and for any unforeseeable circumstance, it all needs to be detailed in the contract. We also have the payment and financing terms. For the purposes of the contract or for the project, whichever amount that is to be paid should also be detailed in the contract, and that will be paying some amount for the whatever for these services from this party. By doing this, it ensures there's clarity and there's also a contract or a document for the parties to fall under. Then we now have, so after doing this, and let's say there's still not enough clarity and parties still have a certain level of miscommunication between both of them, then they might decide to go into dispute resolution. They might need to resolve their dispute, and there are different dispute resolution options that parties can decide to go into. The purpose of this is when you intend to resolve your dispute, parties usually do this with the mindset that they intend to continue their relationship with this party A. But in order for them to do this, they need to go over this dispute. So first and foremost, we have dispute resolution for like negotiation. The part for, let's say, if in terms of the contract, this party didn't put a force major clause, and as a result of that, there was an unforeseeable circumstance, and there was nothing in the contract telling them this is the next step to go forward. At this stage of negotiation, both parties may decide to, okay, we're here to resolve this dispute. We may decide to extend the deadline for the contract for the purpose of whatever is meant to be delivered to a future date. Then we have litigation. Litigation is not always advised, because when you go into litigation, it consumes time, and most times when you go into litigation, it actually destroys the relationship between parties. But if there's need for it, litigation is also a means of resolving disputes. We have conciliation, arbitration, then mediation, where there's a neutral third party which will assist the parties to say, okay, this party wants this and this party wants that. So how do we go from here? Now, why ADR? Before we go into the importance of ADR, litigation is a traditional means of resolving disputes, and by the incumbrance that has been in litigation, the time consumingness, the amount of money parties pays, and the fact that the parties don't always, the decision of litigation may not always reflect the parties' true intention. There's ADR, alternative dispute resolution, and alternative dispute resolution is just has to do with using a set of processes to resolve disputes without resolving to the traditional means, that is litigation. And under alternative dispute resolution, some of the importance of ADR is that it is cost effective, in the sense that for alternative dispute resolution options such as mediation, the total amount of money to be paid during the course of the mediation process is usually decided, unlike litigation, whereby the lawyers we just call their party like, oh, this fee needed for this, and for that. But in mediation, like in ADR, the fee for the process is usually determined. Then time saving. There's usually a fixed period of time for the ADR, for the alternative dispute resolution option. So if it's meant to last for 3 weeks, then the issue must be resolved within that 3 weeks. Then flexibility. The procedures for ADR are not as strict and stringent as litigation. There's more flexible procedures whereby, okay, it's done to suit the needs of the parties and preference of the parties. Confidence, and the next point here is confidentiality. So ADR processes are usually more private and are usually more party oriented. For the purpose of ADR is just basically to attend to the need of the parties. So it's usually more private and just focused on the party. Then we have preservation of relationship. As I have stated, most parties they need to resolve their dispute because they all have the mindset of, oh, we have to continue, we want to retain this relationship with this party, but as a result of this issue on ground, there's something hindering us. When you go into ADR, it's focusing directly on the needs of the party and not just what a set body of rules or standards have put in place. It's easier for them to preserve relationships. So whereby one party is hurting by this, they are able to easily or quickly amend this just to ensure that there's a preservation of relationship. Now, there have been different issues within the energy sectors in Nigeria that have been successfully resolved, meaning that, okay, ADR does work and it has had a tremendous effect on this resolution in the energy sector. So as we can see that in the early 2000s, the Nigerian government and oil companies engaged in a series of disputes over royalty payments and other issues related to the country's oil and gas sector, which was also resolved. We have also seen that in 2010, the Nigerian government and several foreign companies who were involved in a dispute for the ownership of several blocks of oil in the Delta region, this was also resolved. And also in 2010, several international energy companies were involved in a dispute with the Nigerian government for the payment or over the payment of tax and other fees with regards to the operations we did for Nigerian government, and this was also resolved. So from this, we've seen that, okay, yeah, ADR does has an impact in the energy sector and should also be adopted just for ease of process. Now, we're going to the technology and innovation in contract management. That is for data analytics for compliance monitoring. So, as stated, one of the major issues for individuals who want to go into the energy sector, whether you're going into the downstream sector, or you want to retail gas, it's actually compliance monitoring. It's actually compliance to the regulatory body and the regulations. Some people find this hard because either that they are not aware of, oh, they need this permit, they need this license, they need to comply to this regulatory body, or there's a regulation for this, and it hinders the activities. Hence, this is why most companies have a compliance team, which ensures adherence to the regulations. And one of the tools compliance teams make use of is actually data analytics. And it is an essential tool and is for compliance monitoring, whether real-time monitoring, and also helps with incident detection. How this works, some of the functions of data analytics include it helps to identify anomalies and potential compliance breach by looking at the data of, okay, from this month to this month, the compliance will have the whatever all the activities that have been done in the company. If the company intends to go into a new project, they'll be like, okay, you need this permit from this regulatory body for you to lawfully go into this project. It also has assisted in energy consumption and revenue tracking by keeping the data of the company from the profits from the sales or from the transaction between party A and between the company and party B. They will be able to monitor the consumption patterns and their different revenue streams. Another function of the data analysis is regulatory reporting and compliance tracking. This, by doing this, the compliance team will be able to track all the permits. Okay, when will this permit or when will this license expire? When are we renewing this license and all this by just having the data the company has. Then it also assists them in fraud detection and reporting. So automating reporting and ensuring compliance, it will assist by automating the reporting and ensuring compliance with regulatory requirements. So going forward, Nigeria has gone into renewable energy integration, which simply means the process of plugging renewable sources of energy into the electric grid. And by virtue of this, there are some effects that have come into place. That is some future trends, some things that were seen that, okay, this is actually beneficial to the country. And some of this includes economic growth. It boosts economic development by adopting new means of renewable energy. This is a different project from non-renewable energy. It's something that you would need a specific kind of manpower to facilitate such projects. So by going into renewable energy integration, it has helped to create new jobs. Then environmental benefits. We are no longer countries who go into this will no longer be emitting as much gases as the non-renewable energy means. So by going into this, we have seen some environmental benefits such as reducing greenhouse gas emission and pollutants, as well as mitigating climate change impacts. Then for going forward is technological advancements, where we have the energy storage system and smart grid system, whereby smart grid involve just using a specific type of technology to modify the grid to make it more more technologically smart rather. Then going forward, we have social implications. This is also similar to the environmental benefits, but this focuses more on people. It has improved public health by reducing air pollution and enhances quality of life in undeserved communities. So thank you, sir, for the presentation. Thank you, sir. Well, Gutu is doing the presentation. Thank you.
All right, thank you very much, Tommy, for helping out with presentation on behalf of your group. Well done to you and to your group members for putting together that wonderful presentation. So moving forward, right? I think I have a plan in that sense. I would want for us to take questions, and as the mentors are answering the questions, they will also be side by side giving feedback to the presentation. I think that will be a better mechanism to just help us save a little time. So please, we would like to take questions, and as the mentors are answering questions, they would also be giving feedback to the presentation. So can we do that? Please, do we have live questions from our mentees? Do we have anyone with questions so far? I don't know if you were in class, if I was the only one in class, but then while the session was going on, there were a lot of things shared from all three mentors. Like it was such an interactive session. So please, not to waste any time, please, we would like to take questions from the mentees. There's one question that was sent by group 1, right? And I think I would just direct this question to all the mentors. What's their take as they give feedback while we wait for mentees to ask more questions? So the question is, And I think it's just a general question. What is required of a lawyer to perform excellently in the energy industry? I know our different mentors may have different take on this, so I'll be asking all these particular questions to all our three mentors as they give feedback to the presentation and also help with this question. So let me start from the top again. Mr. Uboho, please, what do you have in regards to this advice? Because it's more of an advice than a question. What would you have to say in the light of the question? And also, what are your takes on the presentation, sir?
Okay, thank you. All right, so what do you need to perform excellently in the energy industry? I would answer this taking into consideration the fact that you are students, so would be practitioners. You are still in the process. So as a student, the first thing, I mean, right now, it might not be so clear what your area of interest might be at the end of the day. But if you are one of those who are able to identify that at your student level, you already know where you want to function in, that is the energy industry, then that's a big plus. The next step now is for you to look out for mentors or practitioners who are excelling in that field. Try to contact them. For instance, you can just send a cold email to indicate your interest in the area of practice, seek for guidance and mentorship from them, follow up with the activities, read up on areas that are of interest to you in the energy industry. If oil and gas is that place that you really want to focus on, then you read up, follow experts in that field, try to reach out to them. As a student, another good thing to do is to start interning, in law firms or organizations that are really known or in this field. It really gives you that hands-on experience. And another advantage of internship is it's not just what you are learning. It also gives you one leg, allows you one step into that industry. And when you are done with school, for instance, chances are that if applications are to come in from different applicants, because you interned in that firm, in that company, you would have an advantage in being considered. So identify your area. Is it oil and gas, power? Let it be your area of interest where you are passionate about. Reach out to experts, apply for internships, just try to gain some practical experience even as a student, read up, and also don't be afraid to make a move, have that boldness to take chances. Don't be afraid to fail, make attempts. It's rather you make attempt and fail than to say they're not trying. So try out opportunities, even the ones that you think are too big. Prepare yourself ahead. It's not too late. It's not too early for you to start thinking of making preparation. For instance, before you now writing your final exam, having a plan to maybe write foreign qualifying exams in the future, you can always start from now to plan and prepare ahead. And with regards to the performance of the teams, great performance by the two groups. I just have a few comments for group one. I mean, by and large, you did greatly. The presenters were good. They spoke to their presentation. Even though group two, I couldn't really see the content because the projection was quite small. But for group one, a few comments. The comments you made about joint venture agreements in Nigeria not really being practicable in the oil and gas industry because you need to own, I think you said, properties and stuff like that. Anyway, just to amend that to say that there's nothing special about the joint venture agreement. Just understand a joint venture agreement. That joint operating agreement that we spoke about, that relationship is simply a joint venture, an unincorporated, mostly joint ventures. It's just a coming together of parties to develop an asset and produce, and which is regulated under the joint operating agreement. So it's just a joint operation. So there's nothing special about joint venture agreement that will make it not possible in the oil and gas industry or not common. It's common in the industry. So then for PSCs, you mentioned that you kept mentioning foreign companies. It's really not, meant strictly or exclusively for foreign companies. So the issue is that PSCs generally apply to deep offshore operations, which is in the middle of the sea, for instance, middle of the ocean. It takes it needs a lot of financial investment and skill, technical skill, which is why mostly it's the big companies, the IOCs, multinationals that are able to handle such functions. That is why you have IOCs mainly involved in PSCs, but obviously it's open even to indigenous companies who have the muscle to carry out operations, in such fields. So these are just a few comments I wanted to make, but generally great job, guys. Well done.
All right, thank you so much, Mr. Yang. Please, can we have a response to, sorry, just a moment. Can we have a response to the question? Okay, I can see Abdulbaki, do you have a question you would like to ask?
Yes, so I have a question. And I mean, good afternoon, everyone. Good afternoon, mentors, and good afternoon, Mr. Williams. So I have a question in relation to compliance. And I know that we have a lot of regulators in the energy space. Now, particularly the National Council on Climate Change. Now, the act itself, that's the Climate Change Act, it comes with so many compliance obligations. And to the best of my mind, or to the best of my knowledge thus far, many of those compliance obligations have not really been operational. Now, in the event that the what do you call it now, the council decides to become active or responsive and want to start taking active steps towards enforcing the act. Now, would it be proper for them to, enforce the act on persons who are not compliant as it is? That's my question. I don't know if I put it perfectly. I don't know if you got my questions, please.
All right, thank you so much, Mr. Abdulbaki, for your question. I think I'll be directing that question over to Mr. Ayobami. I would like to ask, did you get his question, sir? And would you like to respond?
Yes. Dennis, I hope you can hear me because I'm calling from a car phone.
Yeah, yes, I can hear you.
Oh, perfect. So yes, I got his question. I mean, I would say yes. Also, I share your sentiment in regards that it's a law that's still not fully operational right now, but the law is still clear. The law is the law, and it's advisable that you'd have to wait until when the agency is knocking on your doors before you're obeying the law. So if you're supposed to give annual reports, for example, if you have a staff of 50 and above, then give your annual reports. Have it on record, because the day something is going to happen, you won't use the excuse that the agency didn't push you to obey the law, basically. So it's important that whether it's being enforced or not, have it on the record that the law has been obeyed. So a similar example was what we had in the cybersecurity fee. I think that's 0.005%. I mean, the law has always been there. I mean, at least for a couple of years or thereabout. But I mean, it just took a day for the government to wake up and we can make money off this, and start, levying, and it caused a bit of commotion at that time in the misinterpretation of the effect, legally. So yes, the law is the law. Whether the agency is knocking on your doors or not, you need to obey it, and that's quite important. Yes.
All right, thank you very much.
Thank you.
All right, thank you very much, sir, for that, for helping us with that. So do we still have any more questions? Do we have any more questions? All right. So I would just want to take a little feedback from Ms. Obo, and then maybe based off of the first question that was asked, if she can just give us a little feedback on the presentation and help us answer the question on board, what it requires of a lawyer to perform excellently in the energy industry. Ms. Obo, are you still with us? Miss Obo, are you with us, ma? Okay. It seems she's not actively on the call. So, okay, Mr. Ayobami, please, you didn't give feedback to the presentation. Please, we would like to take feedback to the presentation from you before we call it a night to class.
Okay. So basically I had but it's good to be, the previous week I think we had all men, so this one we're having all women, so I think it's allowed. Yeah, so it was a good presentation. Just like Uboho said about the JVA, yeah, I cringed a bit when I heard that. Yes, I mean JVA is JVA, whether in the real estate or in the energy space. So it is what you said is quite correct. And I mean, so we shouldn't discriminate against contracting only in the real estate. And so yes. Then also I felt there was a bit of disconnect in when we were discussing about the GENCOs and the Transmission Company of Nigeria and also the DISCOs. So basically, the GENCOs are the one that has power stations. You know, it might be hydro, it might be gas, it might be steam. Yes, I mean, a couple of years ago, I worked on a 3,000 megawatts, which was gas and steam alone. Then we hear about a lot of hydro in Jeba and and the like. So yes, so those are quite what it is. You know, they generate power basically. So they feed the transmission company of Nigeria. Una feeds the discos. The discos are another ones that feed me and you. Yes. So I think I thought there was a disconnect in that. Yes. So apart from that, I mean, all was good. Second presentation I like most, especially just like I liked the last presentation last week, in trying to introduce technology into energy space rather, and I feel it's quite important. I mean, yes, data needs to be driven. I mean, I've been having this conversation with I mean, some weeks ago in Aberdeen, I was part of a conversation, and in Southampton, the ExxonMobil refinery there, and how technology can drive operational efficiency and also drive production in the energy space rather. So yeah, so it's quite important that data should be there. I mean, we should have AI if possible. I mean, not to take away human jobs as much as possible, but I mean, it's quite important that we need the numbers. We need to know. It tells you where things are going wrong. I mean, having a smart grid is a good idea. You know, I mean, having intelligent pipeline piggings is very good. You know, tells you where the pipe is about to burst. Or, you know, tells you when to change, when to do maintenance. So these data-driven things are very important. And I like the fact that energy and innovation, that's the future of, I mean, technology merging with energy to create the future of energy that is better, more efficient, more safer, more climate, friendly kind of energy being produced. Yeah. So yes, that's a good one. Good one to both of you. And if I might just have a bit of a say in concerning the previous question, what's required of a lawyer to perform excellently in energy in the industry. I would say that first have a passion for it. I mean, not everyone is cut out for a particular area of law. You know, my first 4 years in my career, I worked in law firms, you know, in Nigeria and England, but I mean, went to court, you know, but I felt that it was not meant for me, and that's why I did it 10 years ago. I joined the in-house and corporate commercial energy basically and maritime. Yeah, so find your flair first. It might take a while. It's good to dabble in a lot first. I would say it's good for a lawyer to test the waters and go to courts. You know, it helps build your risk appetite. Yes, it does. But when you find it, then you need to invest everything you have in it. Knowledge, laws comes out every day. International conventions comes out every day. So you need to read and read and read. and also get certificates as much as possible, not just for the sake of certificates, but because of learning a lot. In the last 14 years of my career, I always say this: I've been to schools in 4 continents. And I've been to like 10 schools in 4 continents, either doing a certificate or a degree, just trying to, get that knowledge as much as possible, because I know that it's quite important for what I love doing. So yes, invest all you have in it. Save. I remember when I was saving 100 naira to $1,000, and these things cost money. Sometimes I was lucky to have scholarships and everything. So it's good to have, put all you have into it, because to help your future, build your knowledge base, and you'll be better for it. So yes, I think that should answer from my own perspective. Yeah. Thank you.
All right, thank you so much, Mr. Ayoban. So we've come to the end of class, right? But just before we go, let's just kindly turn on our videos, take a quick screenshot, and then call it a day. So please, if you can, I would like to request that you turn on your videos for mentees, please. As much as possible, I encourage you all to turn on your videos so that we can take a quick screenshots. Thank you, Silas. Thank you so much, Mr. Ayobami. Thank you, Tommy. Thank you, Otumba. Thank you, Mr. Abdubaki. Right, it's nice seeing our wonderful faces. All right, yes, we are done. So once again, thank you to our mentors for 5 weeks of your time, 5 weeks of your commitments, and your commitment to training the next generation of energy lawyers, of energy enthusiasts. It has been nice listening to you all, getting a taste of your presentation. Thank you so much, Mr. Obo, for your time and efforts. Thank you, Mr. Ayobami, for your time and efforts. And thank you also, Ms. Obo, for your time and efforts. It has been nice having you all in class and listening to the well springs of knowledge that you've had to share with us. We sincerely do appreciate. I would like to encourage our mentees to share what they have learned on their social media platforms, tag our mentors, do well to connect with them, reach out to them when you can, and then just try as much as possible to keep researching, keep learning, and keep building yourself within this space. Furthermore, more communication about the next subsequent classes, which will be combined, which will be combined classes, will be sent to the group. So kindly pay attention to the informations that will be shared within the main group, so that you do not miss out on the rest of what we have in the coming weeks. Thank you so much to everyone that was in class today. Goodbye, and enjoy the rest of your day.